rights, whereas recognizing of the inherent dignity and of the equal and inalienable rights of all members of the human family is the foundation of freedom, justice, and peace in the world, whereas disregarding contempt for human rights have resulted in barbarous acts which have outraged the conscience of mankind, and the advent of a world in which human beings shall enjoy freedom of speech and the belief in freedom from fear and want has been proclaimed as the highest aspiration of the common people, whereas is the essential if man is not compelled to have recourse as a last resort to a rebellion against tyranny and oppression, that human rights should be protected by the rule of law, whereas it is essential to promote the development and friendly relations between nations, where the people of the United Nations have in the Charter reaffirmed their faith in fundamental human rights and in the dignity and worth of human person and in equal rights of men and women, and have been determined to promote social progress, better standards of life, and larger freedom, whereas member states have pledged themselves to achieve cooperation with the United Nations, the promotion of universal respect for the observance of human rights and fundamental freedoms, whereas a common understanding of the rights and freedoms as the greatest importance of full realization of this pledge. Now, therefore, the General Assembly proclaims the Universal Declarations a common standard of achievement of all peoples and all nations, to the end that every individual keeping this declaration constant at mind and shall strive at teaching and education to promote respect for all the rights and freedoms, and to secure the universal and effective recognition and observe both among the peoples and member state themselves and among the people of territories under their jurisdiction. Federal regulatory agencies influence many business activities and cover product liability, safety, and the regulations and deregulations of public utilities. These bodies have power to enforce specific laws, such as the Federal Trade Commission Act, and have some discretion in establishing operating rules and regulations to guide certain types of industry practices. Because of the discretion and overlapping areas of responsibility, confusion or conflict regarding which agencies have jurisdiction over which activities is permitted, the Federal Trade Commission is the most to influence businesses' activities related to questionable practices that create disputes between businesses and their customers. When the FTC receives a complaint or has a reason to believe that a firm is violating a law, the FTC issues a complaint stating that the business is in violation. If a company continues the questionable practice, the FTC consists a cease and disorder, which can order of the business, which is the order for the business to stop doing whatever has caused the complaint. The role of the government in the American economy is a modified capitalism, because the government regulates business to preserve competition and protect consumers and employers. Federal, state, and local governments intervene in the economy with laws and regulations designed to promote competition and to protect consumers and employees and the environment. Business ethics refers to standards and principles used by society to define appropriate and inappropriate conduct in the workplace and how they affect others. These standards have been codified as laws prohibiting actions unacceptable. Now society increasingly demands that business people behave ethically and socially responsibly toward one another, customers, but including their employees, investors, government, regulators, communities, and everyone. It takes knowledge, skills, experience, and good judgment to be successful. Navigating a fair way to further advance ways to link for employment and work inclusion and being able to build a workforce. The three branches of government are supposed to regulate human resource management. The U.S. government, legislative, executive, and judicial, play an important role in creating a legal environment. The legislative branch consists of two houses of Congress and has enacted a number of laws governing human resource activities. Senators and U.S. representatives generally develop these laws in response to perceived social needs. The executive branch, including the many regulatory agencies that the president oversees, is responsible for enforcing the laws passed by Congress. Agencies do this through a variety of actions, from drawing up regulations detailing how to abide by the laws to filing suit against alleged violators. Some federal agencies involved in regulating human resource management include Equal Employment Opportunity Commission and the Occupational Safety and Health Administration. In addition, the President may issue executive orders, which are directives issued solely by the President without requiring congressional approval. Some executive orders regulate the activities or organized laws that have contracts with the federal government. The judicial branch in the federal court system influences employment law by interpreting the law and holding trials concerning violations of the law. The U.S. Supreme Court, at the head of the justice branch, is the court of the final appeal. Decisions made by the Supreme Court are binding. They can be overturned only through laws passed by Congress. The Civil Rights Act of 1991 was partly designed to overturn Supreme Court decisions. The Equal Employment Opportunity. Efforts to regulate human resource management are those aimed at achieving equal employment opportunity, the condition in which all individuals have an equal chance for employment opportunity. The federal government efforts to create equal employment opportunity include constitutional amendments, legislation, and executive orders, as well as court decisions that interpret the laws. Two amendments to the U.S. Constitution, 13 and 14, have implications for human resource management. 13th Amendment abolishes slavery in the United States. There is still race-based slavery in the United States. 13 amendments have been applied in cases where discrimination involved the badges, symbols, and incidents of slavery. The 14th Amendment forbids the states from taking life, liberty, or property without due process of law, and preserves the states from denying equal protection of the laws. It can be used in abusing the power of authority, charges, or reverse quotas. The current quota system violates individual rights to equal protection under the law. An important point regarding the 14th Amendment is that it applies only to decisions or actions of the government or of private groups whose activities are deemed government actions. So a person could file a claim under the 14th Amendment if he or she had been fired from a state university or a government organization, but not if the person had been fired by a private employer. The periods following Civil War and during the Civil Rights Movement of the 1960s were the time when many voices in society pressed for equal rights. For all without regard to a person's race or sex, Congress passed the laws designed to provide for equal opportunity. In later years, Congress has passed the additional laws that have extended the EEO protection more broadly. Civil Rights Acts of 1866 and 1871. During the Reconstruction, Congress passed two Civil Rights Acts to further the 13th Amendment's goal of abolishing slavery. The Civil Rights Act of 1866 granted all persons the same property rights as the citizens, as well as the right to enter and enforce contracts. Courts have interpreted the later rights as including employment contracts. The Civil Rights Act of 1871 granted all citizens the right to sue in federal court if they feel that they have been deprived of some civil right. Although these laws might seem outdated, they are still used because they allow the plaintiff to recover both compensatory and punitive damages. That is, payment to compensate them for their loss plus additional damages to punish the offender. Under this act, the Equal Pay Act of 1963, men and women in an organization are doing equal work. The employer must pay them equally. The act defines equal in terms of skills, efforts, responsibility, and working conditions. The act allows for reasons why men and women performing the same job might be paid differently. If the pay differences result from differences in seniority, merit, quantity, or quality, or production, or any factor other than sex, such as participating in a training program or working the night shift, then the differences are legal. Vocational Rehabilitation Act of 1973. Congress passed the Vocational Rehabilitation Act to enhance employment opportunity for individuals with disabilities. The act covers executive agencies and contracts and subcontracts that receive more than $2,500 annually from the federal government. These organizations must engage in affirmative actions. A contract creates both rights and obligations. A third party can become involved in a contract in several common ways. These include as a third party beneficiary by narration, by assignment, and by delegation. At common law, only the parties to a contract could sue upon or seek to enforce the contract. Courts held that a stranger to a contract had no rights under it, but courts began to make exceptions to the rule when it seemed evident that the contracting party intended to benefit a third person called a third party beneficiary, a person not party to a contract, but when parties intended to benefit. The rule today specifies that a third party or person expressly benefited by the performance of the contract may enforce it against the promisor if the contracting parties intended to benefit to the third party. Bound is restricted or confined to a specified place, prevented from operating normally by the specified conditions, with definitive certain to do or have something obliged by law, circumstances, or duty to do something. A problematical situation of formal statutory constraint. Someone can be discharged from a contract and leaving someone bound still after, but it must be shown that a novation was intended. However, a novation does not need to be in writing, nor must it be expressed. It can be implied from the parties' actions. When a novation occurs, the original obligor drops out of the picture. The new party takes the original obligator's place and is alone liable for the performance. Assignment is conveyance of rights in contract to a person, not a party. Honorable undertaking is a treaty clause commonly associated with reassurance contracts, encouraging an open dialogue between two parties in a disputed contract. An honorable undertaking clause provides dialogue between two parties to a disputed contract. An honorable undertaking clause provides that arbitrators interpret a dispute reassurance contract as an honorable exchange and not solely as a right legal document. Reassurance contracts typically contains many rules pertaining to how each party agreed to meet its requirements. When disagreements arise, it is up to the courts to interpret what the intentions of each party were at the contract's inception. The inclusion of an honorable undertaking clause in the original contract can help narrow the focus of any substantial legal disagreements. Termination of trust. A trust is automatically terminated when its purpose is fulfilled or when the purpose becomes illegal, impossible, or impractical. Contrary to public policy, the trustor cannot revoke a trust unless it was created under duress, by mistake, or fraud, or under the U.S. practice of revocable trust. He or she has reserved the power to do so. In general, the beneficiaries of a trust who all consent and have the full legal capacity, care of legal age, and of sound mind to act on their own behalf can terminate a trust by forcing the trustees to convey the trust property to them, provided termination does not defect the purpose of trust, irrespective of wishes of the trustees and the trustor. The party may include the original contracts, a prohibition of the assignment of rights thereunder. Such a prohibition of the assignment of rights thereunder, however, is not effective in some states when only the right to money has been assigned. Thus, whether rights may be assigned depends upon their nature and the terms of the contract. Statement of opinion. Statements of opinion as contrasted with statements of fact do not, as a rule, constitute fraud. The person hearing the statement realizes or ought to realize that the other party is merely stating a view and not a fact, but the speaker is an expert on his special knowledge and not available to the other party. Is merely stating a view and not a fact, but if the speaker is an expert or has the special knowledge not available to the other party, should realize that the other party relies on this expert opinion, that a misstatement of opinion of value intentionally made would amount to fraud. Duress.